Any mention?
May it please your lordship. My lord, I crave my lord's permission to file an urgent matter to be listed tomorrow, my lord. This is a transfer posting matter, my lord. Here,
Which department?
This is Assam Rifles, my lord. We have already served a copy.
Why movement order has been issued?
A movement order has been issued, my lord. Now that movement order is in contrary to the medical board's proceeding recommendations, my lord. Much obliged.
May I please, Your Lordship? Your Lordship, I beg to make a mention urgent listing for tomorrow, Your Lordship, for motion. Your Lordship, here the District Council, they have issued an order to conduct a referendum to decide, like on the 7th, that is the day after tomorrow.
Referendum which
in order to decide whether the
which referendum for?
Yes, in order to decide whether the headman of Urksa Wapatau in Ursula, whether he still enjoy the confidence of the people or not. So, and we are like this every yes. Much obliged.
May I plead your lordship? I beg to mention item number 22. I'm appearing on behalf of Madam Sharing Yangi B. Says out of station.
For the petitioner? For the petitioner?
Yes, lordship. Due to medical emergency on account of her husband medical treatment at Hyderabad. Can you take up the matter after 2 weeks? No objection, your lordship.
May I mention item 33 minutes? What's this matter?
One second, yes.
What's 33 minutes? We are also having one matter minutes between the same parties before DB minutes, court 1. But I'm requesting there's an urgent relief if your lordships can have it after lunch minutes at 2:30 minutes. So that there is no clash minutes and I'm able to assess 33 minutes. But it's for final arguments minutes. Just need to address.
Before the division bench.
But we have another matter minutes between the same parties. Was in division bench, so that there is no clash and I am able to assess your lordships. I am requesting if it could be taken.
We will take it as it comes, yes.
Very well.
Also,
very well.
Other matters, yes.
Yes, lordship. Lordship, I beg to mention item number 31. Lordship, I have informed to the private respondent also.
No objection, your lordship.
Yes.
Much less, lordship.
May I please, your lordship? Your lordship, I beg to mention item number 37, your lordship.
No objection, my lord.
Yes.
For the petitioner.
Let this matter come after 2 weeks, your lordship.
Yes.
Much less, lordship.
Similar prayer for item 30, your lordship.
Jumping from this side to this side.
I pray for 2 weeks, your lordship.
Whose other side? Your objection?
No objection, your lordship.
Yes. Yes. Yes, Mr. What's your name? What do you want to mention? Yes.
With the consent of the other, I beg to mention item number 24.
24.
I'm on behalf of respondent number 2.
Why are you joining it?
I'm for respondent number 1.
No objection?
No objections.
Okay, yes. After 3 weeks. When?
After 2 weeks, your lordship.
Okay, yes.
Lordship, I beg to mention item number 29, your lordship. It's a joint request, lordship.
Jose Cherian or is it Jose Cherian?
Yeah, Jose Cherian.
How's it pronounced?
Jose Cherian.
Okay. Yes.
Obliged.
May it please, your lordship, I beg to mention item number 35, your lordship, on behalf of Miss T. Yangi. She's not available, your lordship.
You're there also?
Objections.
Yes, okay. Yes.
Much obliged, lordship.
Lordship, I beg to mention item number 36. 2 weeks, your lordship.
Why? What's the matter about?
It's a regularization.
Regularization. No objection, lordship.
No objection. There should be some objections.
Lordship is for the petitioner to pursue their prayer. I'm here.
Yes.
May I please, your lordship? Your lordship, I beg to mention item number 32, your lordship. The conducting item number 32, your lordship.
Yes. Who's the conducting counsel?
Mr. S.K. Hassan, your lordship. He's out of his station, your lordship. Kindly have this matter after 2 weeks.
No objection, your lordship. Much obliged.
Supplementary list item number 1.
Yes.
May I please, Your Lordship? This matter is pertaining to non-payment of ex gratia amount. Now, the petitioner here is the wife of deceased, Shri Bikram Lama.
When did he die?
He died during parliamentary election, Your Honor, West Bengal.
Oh, it's ex gratia. Okay. Okay. Are you presenting all the respondents? No, that is where is the number 5 election commission? Who represents the election commission?
There doesn't seem to be any.
You can take.
Lordship, I will take 1 to 3. I believe the CEO prefers to.
Heard with S. Thapa, Learning Council Petition Issue Notice. Mr. ESD is present, except on behalf of respondents 1, 2, 3. Notice to issue to remain respondents within 3 days, just after 2 weeks. Yes. There's a ex gratia and election duty. They're given some.
Yes, this is circular. This is
about 10 lakhs, Lordship.
10
is
lakhs.
the.
Do?
See, one thing which I would like before, when this mediation notice was given, it was given to all the parties.
It was, my lord, it should not
Why?
be, but the notice has mentioned all the parties.
Just call for the records of the mediation committee immediately. What? See, I saw this, and who was appointed the mediator? Who was the secretary of the mediation committee? Name was secretary. And you leave that aside, but then the thing is that I don't want to make a judicial order. And he sent it to which person he sent it to also? Who's this report?
Because Lordship had made it.
Why did they see?
Because Lordship had already segregated the matters.
Pointed it out to the when it came mediation. He didn't point it out. You are paying for the village. We allowed you, but even then we should not have allowed you because division bench orders for mediation between the even my order was wrong, I think.
My lord, your order is very clear, my lord. In tune with the division bench order, my lord. I've instructed my party when they appear before the mediation committee. Please point out that the party should be between the our colleague and those are 3 parties only. So notice has maybe erroneously mentioned by the registry, but the parties is between the 3 parties.
How about registry issue notice all of them?
That was erroneous, man. Erroneous.
Yes, it's noted that the matter is returned back from mediation on not being settled. However, this has been reported and it's noted that the mediation as per the orders of the Honorable Division Bench was to be between the respondent number 9 and
my lord, here respondent number 7, 8.
Did the division bench already say that?
They are also party, my lord.
Yes.
No,
Yes.
division bench are not mentioned there.
No, my lord, we are the one, my lord, who raised this issue. Therefore, division bench relegated the matter to this honorable court.
Should be between the CM and
My lord,
the suits pending between whom?
Between the same and the
my lord, same has filed a case and same array him as a defendant and array me as a defendant. And because of that, my lord, division bench relegated the matter.
It's not a defendant, my lord.
No, we are a defendant.
Defendant is not right to.
We were a defendant.
And
See this matter, just take down.
It's not also in the suit of
No, that is wrong. That is wrong.
It is noted that there has been some.
Titus.
It is noted by this court. Also, the matter report has been furnished for a court shown in mediation proceedings have not been successful. However, it's been reported by the counsels before this court that the parties who are not directed by the division bench to be part of mediation proceedings also issued notice. As the steps taken by the mediation committee appears to be irregular, the records of the mediation committee to be produced. To submit it to be put up before this bench in the administrative side. Yes. Now, yes.
My lord, the main matter, the yatra is scheduled for Sunday, my lord.
Why have you come now, Mr. Jindal?
My lord,
the thing is that though this court is not there, other courts were there. It was listed on 22nd.
My lord,
and now you can't expect now within 1 day that to make law and order arrangements. That has become Make it difficult.
My lord, our difficulty was the registry had assured us that there will be a listing, but once we realized that the listing may not be possible in the foreseeable future, we were forced to file the mentioned memo yesterday, my lord. So I admit the fault may be ours that we took a few days to come before this honorable court, but fact of the matter is the fact of Yatra being scheduled for 9th, my lord, it was informed prior also, and because of which my lord had fixed it on 22nd, but unfortunately the mediation
mediation has nothing to do with the main matter. 22nd, when the matter was listed, I had a matter. You should have mentioned it. The urgent matter was mentioned of any other bench.
As I said, my lord, the fault could be ours. But my lord, if I can humbly point out that matter is rather simple at the moment, even as it stands, for the reason, my lord, that last year, if your lordship recalls, on 10th of July, certain SOPs were formulated by the district administration.
With great respect, my lord.
If I can finish, those SOPs, my lord, were adopted by this honorable court with certain modifications, by order dated 11th of July, my lord. So the same SOPs with
When was the Yatra undertaken last year?
Last year, my lord, it was on 1 minute, my lord. 2nd August, if I'm not mistaken, my lord. 2nd August.
That is why there was ample time before. With 24, so it didn't happen because of the shortage of time.
Yes.
And we don't want to create a situation where the administration is put to grave difficulty.
My lord.
To make the arrangements.
My lord.
One day.
My lord. Because the SOPs are already in place. Administration, these are SOPs formulated by the administration, adopted by this honorable court with certain modifications. If the same approach can be adopted for this Yatra also, my lord, I think it will suffice everyone's interest.
We have objection, my lord. Writ petition itself is not maintainable.
Mr. Changreso, one thing you tell your clients also that this Yatra has been happening for a decade before that. And if you have some, it's all in terms of humanity and it is respect for other, for other beliefs and, practices. The thing is that to take technical objections now, you have to try to find a way, to find a way that this, this situation does not, escalate to something else.
My great respect, profound respect, writ petition is not in
it is not a society. What's his name who appeared for the court last year? What was his name?
Man before that, he's already no more. He's resigned.
Who's the present headman?
My lord, Shangbleng, my lord. His term is over. New headman has come. New headman is
I've seen your objection. The objections on taking a registered society. No,
we have taken a plea, my lord. Specifically in the
all these objections,
take only 5 minutes.
All these objections, my lord, can be met. They can be met in 5 minutes.
My lord.
See,
my lord. With great respect, my lord.
That's why we have speak like any objections you might have, which will relate to the eminent performance of the Yatra. That's all. That's what. Not on the question of maintainability and sustainability.
My lord, what happened? Just allow me, my lord. Writ petitioner was registered as a society 2013.
Please don't go there, Mr. Changreso.
It was already expired, my lord.
Have you seen the decisions?
My lord.
So once a society is registered, what does it mean?
My lord, it
does it cease to exist because it does not renew its registration?
My lord, I'll just registration is just only for 3 years.
No,
and 3 years already expired.
Answer the question.
I'll place.
Suppose a society is registered.
Yes.
Right. The society cease to exist.
Cease to exist.
It does not.
So what happens to assets of that
society? Therefore, 3 years given, only 3 years given to the petitioner.
That argument is we're not going to accept now because the only question before the court at that time, 22nd, decide whether you have any objections to the performance of Yatra on the date that they say that is the date to perform. That's all. So that objections to that extent. Correct.
I agree.
And so, not on the main merit of the matter, that will examine.
Therefore, at that stage of my lordship correctly pointed out, pleading of exchange was not there completed. Therefore, lordship in interim judiciously passed that order. We also give us under the allowed.
I don't want you to
but now here,
objection that you can that argument you can make at length with regard to whether it still exists society, whether they can come here, whether he's the register or the whatever office bearer he is.
Your lordship last order, we have submitted a written argument also, exchange our argument. Now I'll take only 10 minutes, my lord, to satisfy the writ petition not maintainable. If it is not maintainable, my lord.
We'll not go there today.
If it is not maintainable, my lord.
The situation
is not
before us. This
for the
order 10 July.
10 July, my lord, SOPs were submitted. 11th July is the order.
You have to ask for a appearance of the deputy commissioner. Who's appearing for the state?
learned AG, I think.
I'm appearing for this statement. I'm appearing for this statement.
But MS Yangi is not here also.
Yes,
Order 25.
he is in some personal.
My lord.
25. 10 July?
10 July 25, my lord. The SOPs were formulated and reflected in order dated 11th July.
July, it's with regard to 10 July only that Division bench dated 26.
No, my lord. There is a letter addressed to the government advocate, Mr. Abraham, from the Deputy Commissioner.
Where it's not part of the
It's
order.
part of the record, reflected in 11th July order, my lord.
Yeah. See, Mr. Chandrasekhar, you've seen this order 11.
My lord.
Yes. So that is
11 July.
At para 2, you kindly see.
My lord.
So before we go to your maintainability question.
My lord.
Yes.
Sons and matters submitted is only a pilgrimage, and the same is under the supervision of the district authorities. My lord. The said respondents have no objection to the said letter, but will remain that as undertaken by the petitioner, there should be no performance of puja or any articles for performance of which.
The same conditions apply. You.
He has given some undertaking.
If they are
some undertaking, therefore, that was the concession, matter, and that is, my lord, in the active process of my exchange of pleadings. My exchange of pleading, everything is finished now. In Lordship, earlier occasion we pointed out, and Lordship fixed the matter, appreciating the urgency, man. It's a very difficult situation in the village.
But then this court is not available, and they also should have mentioned it.
Well,
you should have
suddenly,
it's an urgent matter. So things that we don't put. See, the thing is that whatever is already in place is in place. Everything is to be considered. Correct. Only thing is, what we're concerned with is now is the time factor, and whether the district administration is in a position to ensure that the permission be granted and the Yatra to perform. That's what it is.
If it is not the case that they have to hold it on 9 itself. They can hold it at any time.
No, that's not possible, because that's not possible because the public has been mobilized for the 9th, my lord.
No, forget problem. Is there any other auspicious day, which is?
My instruction is, my lord, that 9th is the last possible window, my lord.
Anyone else who can throw any light with regard to?
No idea.
Yes. No idea.
No idea.
My lord, sir, so far as we are concerned, my lords, I join the request of Mr. Jindal. And my lords, my respectful submission is that the arrangement which was made on 11 July, the same arrangement can continue this year also.
Yes, Mr. Shankar, that is all right. But now we have to look at the prevailing situation on the ground and whether the administration will pass an order. Then let them come back. Mr. Advocate General, you just carry back the instructions over there, Mr. Abraham. Yes,
madam.
Take down.
Yes, my lord, if I can also make a small request, my lord, the last year's order, para 3, it spoke of sprinkling of water.
It'll be the same thing. We can't. If you want the same order, you'll have to.
My lord, the sprinkling.
Yes,
my lord, if I may, my lord, sprinkling, my lord, amounts to disrespect. We were not aware of this position last year, so we agreed to the sprinkling. But sprinkling, my lord, my instruction is it amounts to disrespect. We may be allowed to pour nominal water, my lord, maybe 500.
See, Mr. Jindal,
my lord,
you're putting this court in the back foot, with regard to with regard to the late. You mentioned on 22nd.
My lord.
And this court was there from last week from 27.
My lord, as I said, my lord, we were
7th from 27 July. This court was there.
My lord,
yes.
My lord, not to burden this honorable court with unnecessary details, but we were relying on the registry. Once we realized that it may not be possible through the registry's listing, we came before
it's
this.
It's always open to the lawyers if the matter is fixed and it's not listed subsequently. They will not be aware of the urgency. That's the only consideration. You take down, yes, this matters appear today on being mentioned by the learned counsel for the petitioner. Stop. Mr. S. Jindal, learned counsel, has submitted that the mention was made due to the fact that though the matter was fixed for 22nd, due to the unavailability of the court, the date was not provided. The next date was not provided. Stop. He submits that the urgency in the matter today is that the yatra, which is an annual affair.
Yes.
Yes, it's is to be conducted on the 9th of August 2026, and he prays that suitable directions be passed as per the order dated 11/07/2025, whereby that's the SOP which was provided by the state respondents was taken note of by this court, and the yatra could be conducted. Stop. On behalf of the state respondent, Learned Advocate General has submitted that this matter will have to be examined by the district authorities, as it involves the arrangement and the maintenance of public law and order, apart from other necessities that have been put in place. Stop. From the part of the respondents number 6 to 8.
6 to 8. 5 to 7.
5 to 7.
6, 7, 8.
Counsel, Mr. Chanreso, has submitted that as the matter is already the fag end,
yes,
and pleadings are complete, perhaps the hearing can be concluded,
yes,
to put a quietus to
yes,
the entire matter. Who are the other respondents?
Well, respondent number 11 to 15. Which I am appearing for.
Respondent number 11 to 15 also support the prayer made by the Learned Counsel for the petitioner. Stop. This court on hearing submission from the Act of Mediation Santo. This court on hearing first notes that the matter sent in mediation with regard to the other aspect, that is the prayer of the petitioner society for conduct of the yatra on the 9th. The perusal of the order dated 11/7/2025 would show that on the last occasion, the respondent 6 to 8 also had submitted that, as it seems under supervision of the district authorities, they would have no objection, but will maintain that as under your petitioner, there shall be no performance puja, any articles for performance such rituals, which was recorded in para 2 of the order. Stop. In this view of the matter, and in view of the shortage of time, the Learned Advocate General is directed to obtain urgent instructions to be placed by tomorrow as to whether district authorities will be in a position to allow the conduct of the yatra on 9th as scheduled. Yes, list on 7th.
Grateful.
Grateful, madam.
3.
Please, Chief, this one was the one just day before yesterday where I had submitted.
Remember, this one was the one, meaning?
This was the one where I had filed, I had made submission. It was just day before yesterday only, where I had made submission.
Lordship, I am appearing on behalf of Ma'am Olivia, as Bank says unable to present before this honorable court as due to some family member engagements you have said. So kindly take up the matter after 1 week.
1 week. It's already fixed. It's on 17. Because it was filed, that's why it has come.
Yes, this case 214. This is matter with the main case.
With the main case on
the next date.
On the next date. Lordship.
Daily list, item number 1.
You all file affidavits? They file affidavits?
Yes. The pleading possibly is ready, madam.
So we can conclude the hearing today.
I hope it's a very short matter, my lord. Constitution to the assent. Lord, your lordship will find.
1 second, sir.
Yes, yes.
See, before the senior counsel starts, the thing is, this court again will reiterate that we will confine ourselves only to the legality of the orders passed by the district authority. Regarding the other things, we will not, because it has to go into a different arena. So we will not.
Well, as a matter of fact, I must inform this honorable court, we file an additional affidavit. We have agitated this issue before the church.
Yeah.
In terms of the constitution, and they have issued notice on this matter as well.
See, we don't want also to go that. Only that they have grievance with the
this particular
with the
order,
nature of the orders and what it.
Lord, a very short point I will say.
Very good.
The lordship is called upon to decide whether the order passed by the DC is tenable, my lord, whether it has got an illegal mandate.
Yes.
Now, in order to, my lord,
But for all our file, you file affidavit. Yes. Status file. Mr. Chanda, it appears with Mr. Paul.
My lord, before going into the matter, Lord, I would like to read Article 25 and 26 in order to, my lord, clarify the impugn order. Now, kindly, your lordship, look at Article 26. Precisely, that is the contention before your lordship. And your lordship only called upon to decide that matter only.
Yes.
Lordship, kindly see Article 26.
You just send your note from the right side of my table. Yes.
Lord, Article 26 I will read.
Yes, please.
Freedom to manage religious affairs. The first phrase is very important, my lord. Subject to, is the lordship got that?
Yes.
Subject to public order, morality and health, every religious denomination or any section thereof shall have the right, your lordship may kindly see B, we are concerned in relating to that only, to manage its own affairs in matters of religion. Now, my lord, in order to, my lord, pass any order by the DC, my lord, he'll have to satisfy himself that public order, disruption of public order, morality and health is really attracted or not. And that will have to be, my lord, reflected from the order itself. Now I will take your lordships to the order passed by the DC, my lord, which your lordship will find at page 118. This is the impugn order.
118.
118, my lord.
116, not the impugn order.
No, 118 is the impugn order. This is addressed to Secretary Mokhar Presbyterian Church.
1 second.
116 is addressed to, my lord, the
Just question set aside 19/6, 2026. Quite said. You have impugned 4 orders.
Yes, yes.
No, more than that.
More than that, but then main order is
which one?
118. That is the passed by the Deputy Commissioner East Shields.
Okay. Yes.
Now this is addressed to G. Pakma, Secretary, Mokhar Presbyterian Church. And the contents is like this. With reference to your letters referred above, I am to state that your contention that providing pastoral care by the Synod Minhi does not amount to external affairs in the affairs of the Mokhar Presbyterian Church is not tenable.
Also, the contention does not amount, yes.
Is not tenable since the Presbyterian Church of India has clarified that the provision of pastoral services by another synod would amount to the de facto ecclesiastical recognition of that congregation as falling under its jurisdiction, even though it completely lacks legal validity. The Presbyterian Church of India has further clarified that a local church under a synod cannot dissociate from its current synod to seek affiliation with another based solely on a resolution passed by its communicant members, and that it is mandatory for a local church to seek prior approval or sanction for a change of affiliation and or release from the district pastorates, presbyteries and synod to which it belongs in accordance with Article B, Clause 1 of the Constitution PCA. In view of the above, you are hereby directed to take up the matter of pastoral care and ecclesiastical services with the competent authority as provided under chapter so and so, so and so. Now, at the first instance, your Lordship will find whether the DC has the authority. Now, your Lordship will find so far Article 25 and 26, my Lord, the amending provision is given to the Parliament. Now, Parliament, there exist two kinds of law where the Parliament can interfere. Parliament can, my Lord, enact law in terms of the legislative power.
Yes.
That is the one phase. And the second phase, my Lord, the Parliament can, it is the only Parliament who can amend the provision, any provision of the Constitution, save and except, my Lord, the basic structure doctrine. Now here, if your Lordship look at 25 and 26, it relates to secular fabric of the country. Now any event, my Lord, if the Parliament has given the power to amend any provision of the Constitution, it cannot amend the basic structure doctrine. Therefore, Article 25 and 26 cannot be amended even by the Parliament. So in that context, whether DC, the way the order has been passed, he has amended the Constitution.
But one thing, Mr. Datta, is referred to the Presbyterian Church of India, which is the apex body, correct?
Whether he can do that, whether he can enter into that arena, that is the question, my Lord. This is the internal affairs of the Church Committee. The DC has no power to go into the unless.
Second last paragraph. In view of the above, you are hereby directed to take up the matter of pastoral care and ecclesiastical services with the competent authority provided by the Constitution. Correct? That
even that position is factually not correct. My Lord, if I can take your Lordships to the Constitution of the Constitution of the PCI, my Lord.
Chapter 2, Article C.
My Lord, if I can provide your Lordship to that.
This one?
Yes. Yes. कहाँ था? This one is? No. Synod. If your Lordship come at page 38.
38 of the petition?
No, 38 of the PCI Constitution.
Presbytery?
Yes.
That is at page 19 of this. You give the Senior Counsel a copy of the blue book also.
Lord, I am furnishing one book to your Lordship with the page will tell you.
Is that different from this one?
So are you referring to this one only? Referring to this one only?
Yes. The page should be the same, no?
Page? You're referring to page? So the page is because of the font.
Page 19.
The contents will be the same, page may be different, no?
Presbytery. Wait, is it the Presbytery?
19, page 19 of this.
Page 19.
Blue book.
If your Lordship come at page 29 first. What are they? Executive Committee.
Executive
Committee. Page 29, my Lord, give it to our given, na?
That one?
It's the same, my lords.
The same, only page will be different.
No, it's the same page.
Same page.
Okay. My lords have the same book.
Page 29.
Page 29?
Yes.
The last para, my Lord, Roman 3.
Yes.
It shall cater to the spiritual needs of the Christian population within its jurisdiction, including the needs of the Christians from other synods and church traditions, and provide for the evangelization of the people of other faiths within the area, and submit its recommendations to the synod. So therefore, there is no geographical boundary so that we cannot bring another synod from another area.
Executive committee of the synod, this one.
Yes.
Okay.
So therefore,
that shall cater to the Christian policy within its jurisdiction.
right.
Within its jurisdiction, meaning is it territorial or is it
No,
is it
there-
territorial or is it
So far,
please enlighten the court.
so far synod is concerned, my lord, there cannot be a territorial jurisdiction
There's no
because
territorial jurisdiction.
a synod from Khashi Hills, they are going to Assam for give the pastoral services and all that. So therefore, a priest from Calcutta comes in Shillong to give the services of a priest. So it is something very peculiar thing to say that the synod cannot go anywhere except the Shillong. And it will have a geographical or a territorial jurisdiction, cannot, my lord. And this clearly justifies that. Then another provision, your lordship, kindly come to page 38. 38 clause D.
1 second. Thirty-eight.
38D, my lord.
This is a general assembly. 7.
This refers to powers and functions of what
General
body?
Assembly, my lords. Page 36, my lords, may I kindly have a look at it.
36 Committee of the General Assembly.
General Assembly.
It attracts.
This is there shall be one highest church court with authority over the church grounds also. The court shall be called the General Assembly.
That is why General Assembly. Now here in D, your lordship will find, it shall make provisions for the spiritual needs of the Christian population where there is movement from one synod area to another or to an area outside that covered by the General Assembly. So there is no distinct area that he will have to be confined in that area only. So therefore, these, my lord, in the impune order, my book, at page 118, in view of the above, you are hereby directed to take up the matter of pastoral care and ecclesiastical services with the competent authority as provided in the
One thing
chapter
is
so
you
and
have to
so.
satisfy this court as why you see it's illegal, because what they've done, they've just the second paragraph. The Presbytery of India has further clarified that local church and the synod cannot dissociate from current synod. Is what you're right.
Yes. Now
He's just
whether
replicating what has been fed to him, that is the commissioner.
the clause C, your lordship can see article chapter
Yes.
2. Let me see. Chapter 2, article C, clause 7. Where is that? In which page?
Terms of reference and duties. Page 21.
Page
So you can see till page 21.
21.
Yes.
Clause, I mean 25, your lordship kindly see at page 25. Clause D, the synod.
So you're referring to this chapter 2, article C, clause 7 and 12C.
That is at page 21. Well, it's 7. Your lordships will find at page 21.
7 terms of reference and duties.
Yes, yes.
Okay.
This deals with the presbytery.
Then in regard to synod, your lordship will find at page 25.
Okay.
The DC has referred these C, clause 7 and 12C.
No, he's not referred to this.
No. 7 and 12C is in page 7 and 21.
21.
And 12C is in
synod.
12C in 23.
12C is 23.
23. It's 23. Sub-pastoral committee.
Sub-pastoral committee. Sub-pastoral committee shall consist of the moderator and the secretaries and 9 members elected by the presbytery from among the permanent office bearers of the church, 2 of whom shall represent the presbytery to the pastoral committee of the synod. The sub-pastoral committee shall have power to make temporary arrangement which it may deem necessary. It shall deal with all matters relating to pastoral care within the presbytery and shall submit its recommendation to the presbytery. Now the question is, my lord, whether the DC has any authority to go into all these things. My lord, only thing he'll has to first thing at first instance, he'll have to show there is a disruption of public order, morality, and morality includes constitutional morality, my lord. And if we look at constitutional morality, that has been disrupted by the DC himself, because the meaning of the constitutional morality, as Supreme Court has said, it is we should bow down to the rules of the Constitution. Now, whether the DC has done it, the DC has, as if DC has been in the above the Parliament. He has the power, even if that constitutional provision in regard to 25 and 26, that can be amended by the DC. That position DC has taken. And this is the constituent power of the Parliament. That is also limited power. My lord, it is limited in the sense only basic structure, except basic structure you cannot dilute. Apart from that, any other thing. Now, this is the basic structure. 25 and 26 relates to basic structure because it's relates to the secular fabric of the country. So, in any conditions, my lord, Parliament even cannot dilute that 25, 26. Now, the DC has done that. Now, whether he can do it on the face of explanation given by him on the concept of Presbyterian Constitution. Now, he can enter into subject to all these things, these ingredients will have to be satisfied. Now, he could not do that. Therefore, my lord, I will take your lordships to the certain decision of the Supreme Court in order to justify whether they can do all these things. Where is my? This is my copy. Take it out on your laptop. Two weeks on this thing. My lord, I will take your lordships 1954 1 SCC page 487. 4 copy भी लग दिया ना के लोग. I will take your lordships to paragraph 16 and 18. Is that na? My lord, your lordship kindly see at page paragraph 16 at page.
Yes.
So far as Article 26 is concerned, it deals with a particular aspect of the subject of religious freedom. Under this article, any religious denomination or a section of it has the guaranteed right to establish and maintain institutions for religious and charitable purposes and to manage its own way all affairs in matters of religion. Rights are also given to such denomination or a section of it to acquire and own movable and immovable properties and to administer such properties in accordance with the law. The language of the two clauses B and D of Article 26 would at once bring out the difference between the two. In regard to affairs and matters of religion, the right of management given to a religious body is a guaranteed fundamental right which no legislation can take away. On the other hand, as regards administration of property, that part we are not is not required, my lord. Your lordship can speak. Skip that. Then your lordship kindly come at paragraph 18. Religious practices or performances of acts in pursuance of religious belief are as much a part of religion as faith or belief in particular doctrines. Thus, if the tenets of the Jain or the Parsi religion lay down that certain rites and ceremonies are to be performed at certain times and in a particular manner, it cannot be said that these are secular activities partaking of commercial or economic character simply because they involve expenditure of money or employment of priests or the use of marketable commodities. No outside authority has any right to say that these are not essential parts of religion, and it is not open to the secular authority to the state to restrict or prohibit them in any manner, the like under the guise of administering the trust state. Of course, the scale of expenses to be incurred in connection with these religious observances may be and is a matter of administration of property belonging to religious institutions. And if the expenses on these heads are likely to deplete the endowed properties or affect the stability of the institution, proper control can certainly be exercised by state agencies as the law provides. We may refer to connection to the observation of so and so, so and so, and although they were made in a case where the question was whether the bequest of property by a perceived testator for the purpose of perpetual celebration of ceremonies like so and so, which are sanctioned by the so and so religion, were valid charitable gifts, the observation we think are quite appropriate for our present purpose. If this is the belief of the community, thus observed the learned judge, and it is proved undoubtedly to be the belief of the Zoroastrian community, the secular judge is bound to accept that belief. It is not for him to sit in judgment on that belief. He has no right to interfere with the conscience of a donor who makes a gift in favor of what he believes to be the advancement of his religion and the welfare of his community or mankind. These observations do, in our opinion, afford an indication of the measure protection that is given by Article 25 of our Constitution. So, my Lord, Article 26B is the absolute power given to the religious institution which nobody can question and nobody can amend. Even the Parliament also cannot amend that. Now I will take your lordships to AIR 54 Supreme Court 388. This is what is that?
Sir, which citation?
54, AIR 54 Supreme Court 388. My Lord, your lordship may kindly see at paragraph 11 and 13.
Can I give? Yes. Have you given list of books?
Hey, what are you doing?
Yeah, 1954.
Paras 11 and?
Para 11 and 13.
Yes.
388. My Lord, I'll read it slowly and give it
No, at
to
least
you.
you kindly you furnish a list of books, so at least you can
No,
get it out
I'm
from
having all the copies, my Lord. They're possibly mixing up. Serially, you keep on this. Your lordship may kindly come to paragraph 11.
Yes.
(11) and 13. My Lord.
Okay. Yes.
So far as Article 13 is concerned, it deals with a particular aspect of
Which
the.
judgment is this?
This is
This is 54.
54 Supreme Court 388. Ratilal.
Given this, the earlier judgment you given is the same one. You kindly take it back. It's the same judgment earlier given.
Yes,
This sounds very.
I'm sorry, my Lord.
One is AIR, one citation is AIR, one citation is.
So they given the same
Same
copy twice.
No, but it's the same judgment, but it's one in SEC citation, one in AIR citation.
For the same judgment. Then
Let me see.
Is Ratilal
yes,
Panchand
this
Gandhi
is
versus State
Ratilal
of Bombay.
Panchand Gandhi
Versus State of Bombay.
So it's in 54 SC 388 the same.
Yes.
Just to impress upon.
Just your lordship, I'll see to it later. Now the next judgment I will take to your lordships too. That is AIR 54 Supreme Court 282.
Wait.
Commissioner Hindu Religious Endowment. These are all you make serially, huh?
This is Commissioner
of Hindu Religious Endowments versus Lakshmindra Tirtha.
Paragraph?
My Lord, paragraph 14 to 23.
Yes. Yes. This is SCR.
SCR, this is SCR.
Volume given, the copy given to the court is SCR, not EIR.
In 54 SCR 1005.
Yes, which paragraphs?
Paragraph 14 to 23. You given, na?
There are no paragraphs here.
SCR will not have paragraphs.
Those are paragraphs.
No, no.
SCR citation.
SCR citation not have paragraphs.
This is, my lord, equal to 1954 SCR 1005
It doesn't have paragraphs. They don't have paragraphs in SCR.
does not have
It's
paragraphs.
full reports. I think we'll adjourn the hearing until we, after some time, we take up the other matters first. Kindly,
after some time.
you kindly arrange
I'll just arrange it. Mate.
We will not get anywhere. All other matters.
2. Item number 2.
Please take the listing so that you are not running around. Put it some other document. Well, okay.
The petitioner.
I extend my apology, my lord. I missed the matter on the last occasion. I'm praying for a week's time to file my rejoinder, my lord.
Last watch you given.
That was the only, my lord. I'll matter maybe.
For hearing.
I'll just, in the meantime, I'll file it, my lord. In the meantime, I'll file it.
No meantime.
It was only one occasion where I asked for rejoinder, time to file rejoinder, my lord. I missed it on the last.
3.
In the meantime, it can be.
Take down.
I apologize.
Mr. S. Deb submits the due to inadvertence.
Absolutely. On my part.
On the last date. He prays that he may be allowed to ask for you to file rejoinder in 1 week. How much cost you'll pay?
I'll pray for only 1 week's time, my lord. I'll
pay cost.
My lord, it perhaps won't be possible because.
What's only possible?
I'm filing the petition for them to pay me some money, my lord. Which.
So.
I'm just praying for a week's time, lordship. In the meantime, may have it for hearing.
3.
Obliged.
Your Lordship, we've
Complied.
already filed. Yes, Your Lordship.
No, my lord, this has not been complied. What was the order? My lord, may kindly see the division bench order.
What do you say?
Page 15 of my contempt petition. Para 2.
Yes.
Even accordingly to the respondent, the deceased husband of the writ petitioner has rendered 17 years of continuous service, and in view of section so and so, he will be otherwise entitled to the payment of gratuity on his resignation. Gratuity has not been given to us, my lord.
DCRG has been given, Your Lordship. They are eligible for DCRG, Your Lordship.
No, my lord, I am eligible for gratuity, my lord. 17 years of my service.
He submitted his resignation, Your
My
Lordship.
lord, let them file an affidavit. Why gratuity should not be given to me? They have not clarified anything, my lord, in their affidavit.
Have you filed affidavit already?
Yes, Your Lordship, we've already filed our affidavit. DCRG has already been given, Your Lordship.
Where is that?
Of 11,000 rupees only, my lord. Page 7 of the affidavit, my lord.
Page 3.
Page 3, para 6, Your Lordship.
Yes. You resigned from service.
Yes, Your Lordship.
Yes, but 17 years I have served, my lord. Whether I was entitled for gratuity or not, my lord, they have not disclosed anything. Why I am not entitled? Where there is a specific order, like I am entitled for gratuity, my lord, they should have given me. Or
No,
they
but
should have.
see, continuous service 17 years.
Yes, my lord.
Maybe you just.
I'll take instructions, Your Lordship.
Yes, Sadhu, MS Ailingwa submits that the order still violated has been complied with. Just they has raised objections to manner of compliance. Stop. Energy praise below
3 weeks' time, Your Lordship.
2 weeks time to obtain for the instructions.
Much obliged, Your Lordship.
But here I have taken step to the other respondent lordship, that accountant general lordship. But
Yet to receive copies.
yet to receive, I'll supply the copies to them. But so far as the state, my lord, they are refusing.
Why do you give to the wrong person? It's in the last order.
My lord.
It's in the last order of this court, 26-6. Mr. Marak didn't tell you. Order was passed. Read the last order.
My lord. I'll take it.
You read the last order. Here, take. You haven't seen the last order.
No, my lord.
At least you should read the last order with the court before you appear in the matter. You have to know where the matter is going. This is a basic thing.
No, my lord. We have submitted, this is not correct, lordship. We have submitted the succession certificate to all the respondent, lordship. Even they are also, as well as the AG also,
My
lordship.
submission was that it will be the AG account who will be deciding. So
I have
and AG
submitted my
account has denied that they have received it. That was the situation. Because from our side, my lord, we have never objected to her entitlement, my lord.
Yes.
Lordship, let the copies be sent.
Yes, MSP Vasa is present today. Honorable Conversation submits that he is yet to receive the copy of the contempt application. Learned Counsel should supply the same the course of the day. Just after 2 weeks.
I have submitted to all the respondent, lordship. In fact, this is no succession but legal heirship certificate, lordship.
Whatever, yes. Rejoinder?
5.
Please, Lordship. Filing today, Lordship. Copies have been served.
Yes, Mr. Khalkan submits that.
Rejoinder will be filed.
Only it's a matter for hearing after
2 weeks, Lordship. There's also an interim order, Lordship.
interim order. We need to continue the next hearing.
Obliged.
6.
May please, Your Lordship.
Your Lordship, affidavit has been filed, my lord.
May please, Your Lordship. Your Lordship, I am praying for 2 weeks' time to be allowed to file my rejoinder.
What about 3 and 4?
3 and 4.
Already filed?
Yes.
Yes. Appealing the
Yes, Your Lordship.
the opinion on behalf of the petitioner. Case was allowed. How much time?
2 weeks' time, Your Lordship.
File count to file. The general affairs filed by the respondents.
Highly obliged, Your
Much obliged, my lord.
7.
May I please, Your Lordship? I beg to I'm seeking some more time, Your Lordship. I'm seeking some more time, Your Lordship, to file rejoinder.
How many times you start?
Second time, Your Lordship.
Yes. MSN Sangma.
Yes, Lordship.
Please not allowed further to stand for the joinder list. After and so on.
Highly obliged, Lordship.
8.
Here there is matter, lordship. As per the last order, I was supposed to take some the details of the respondent number 6, lordship, private respondent. So I need some more time to have the complete details, lordship.
5 or 6?
5, lordship. The private respondent. Another 3 weeks time may be given so that I can.
For the frequent to obtain correct address for number 5. Praise allowed, yes. Just after 3 weeks. You file affidavit?
Yes, Your Lordship.
They file it.
9.
May I please, Your Lordship? Here we will file the rejoinder, Lordship.
You won't file?
We will file, Lordship. Some more time, Lordship.
Yes, 2 weeks for the time as prayed allowed to join them.
Must.
10.
Your Lordship, as per the order, last order 7 July, they have not complied till.
This is whose case?
Sorry.
10.
Yes. No. This is number 9. But this is number 10.
Yes.
10.
Now 9. Skip 9, eh? Skip.
Sorry, 9.
Yes, 9 first. Yes, 9. Where's Mr. Karangdo?
9.
Opiti Sangma.
9.
9, yes.
Please, Lordship. Number 9. Lordship, this matter I may be allowed to just file a more rejoinder today. Affidavit maybe can be listed for hearing. At the meantime, I will just file it.
Order has already been passed.
Order has already been 9. Item number 9.
Yes, 9.
9. Yes.
Which item? Kalindo appeared which item?
Oh, what is it?
What's the item?
Item 12.
10.
What the confusion? Yes, Mr. Sangwan.
My lord, last order said the state is to give instruction, and also the respondent number 5 is to present today.
Lordship, I'm entering appearance on behalf of respondent number 5, NHID. Lordship.
May it please your lordship. Your lordship, on the last occasion we had submitted that there was the inquiry that was conducted was inconclusive, your lordship. I have been informed, your lordship, that a fresh inquiry has just been conducted yesterday. So I'm praying for some time, your lordship, so that we may place the report of the inquiry.
As Pandit under the appearance, we have the respondent number 5, which notice complete all respondents. Top next paragraph, MSZE non-criminal JA submitted that the pursuant to the order dated 15/7/2026, instructions have been received and a fresh inquiry has since been conducted. He prays for 2 weeks' time to bring the same on record.
Your lordship.
Going to file affidavit? No.
Lordship, we'll file, Lordship.
Mr. S. Pandey also prays and be allowed to file affidavit in the meanwhile. Yes, this up to 2
Obliged,
weeks.
your lordship.
2 weeks.
2 weeks, your lordship.
Yes.
11.
Lordship, they've filed a detailed affidavit, Lordship. I'm praying for some time, Lordship, to reply to their affidavit, Lordship. 2 weeks,
Yes,
Lordship, will be granted.
Contempt response allowed 2 weeks time to file rejoinder. The affidavit filed by the respondent, yes.
Hello.
12.
Then item number 12, Milords, I have received the instructions that check in the name of Milords petitioner has been Milords issued, and Milords it will be handed over Milords in 1 or 2 days time. So check has been issued.
Take down, Mr. S. Pandey submits that the entire amount or rupees 20,000, 4 rupees.
8,20,000.
Yes, 820,000.
8,20,000, 4 rupees.
4 rupees, yes.
Has since been sanctioned and a check has been drawn. So if the submits are the same, will be handed over to the petitioner within a period of 1 week from today.
Yes, ma'am.
This list after 2 weeks.
Hello.
For the orders, yes.
13.
In the course of the day,
yes?
Affidavit will be filed in the course of the day.
The course of the day. Very good. Yes. Mr. Keeper Energy submits that after the final course of the day, just after 2 weeks for rejoinder of any.
Yes, 2 weeks. 14.
No affidavits yet, my lord, but on the last occasion I had placed a letter regarding the appointment of the CVO, my lord.
What did you have to say in the letter, Mr. Sen?
We have seen. Correct.
Yes?
Lordship, so far as the term of the part-time CVO, that has expired, Lordship. She's no longer a part-time CVO.
She's so 3 years. That was not, I don't know from where the 3 months thing is coming, my lord.
This is only a communication, Lordship. As on 7, that is the last
Then who can clarify that it was never for 3 months?
Over.
It's over.
Yeah,
Lordship.
it's
I
over,
can
man.
produce a communication.
We have verified it's over.
Now who's the new CVO?
Now the Nehul, they'll have to take steps, Lordship.
We yet
Matter can be closed, Lordship.
Yes, show me that communication.
This is a communication.
I have a copy.
I don't know.
Because her own letter said it was for 3 years.
But that has been clarified. Can you see the last page of this compilation, Lordship? Lordship, can you see para 2? The undersigned is directed to convey in this regard that the maximum permission
as a grievance of the petitioner no longer survives in view of the communication dated 11/6/2026, whereby the short-term arrangement of an acting CVO,
part-time CVO,
since expired, nothing remains for consideration in the instant matter the same is disposed of.
May I,
copy of the communication is taken on board with the record. Furnish him a copy also.
May I make one submission, my lord, that any fresh appointment should be made as per the rules.
Let the who decide.
Very well.
But can we direct executive council decide in a certain manner?
Once again, it will come. Very well. Obliged.
Highly obliged.
Lordship, here in this case, Lordship, they are saying that they cannot process the pension paper because of the death certificate, Lordship. Here I have approached to the register of birth and date at Gwalpara, Lordship, but they are not issuing, Lordship. So I have made a prayer number 1 and 2, Lordship. So that is the difficulty the petitioner is facing, Lordship, because her husband died at the residence of the daughter from the first wife, Lordship.
Now they've been served 5 and 6 not appeared. Then
Yes,
what
Lordship.
to do?
Well, only that if they can issue a death certificate subject to the production of.
They have not appeared.
They have not appeared before us.
My lord,
Only file our
notice has already been served, Lordship.
Number 5 is whom? The wife.
And she is the daughter from the first wife, Lordship. She is major.
But they both stay in Golpara.
Yes, Lordship. And the
You
petitioner.
also stay in Golpara.
Pardon?
You also stay in Golpara only.
The petitioner also. Yes.
Agia.
Yes, Agia.
Yes.
All fall within the jurisdiction of Gwalpara, that register, Lordship. Now in their affidavit they are saying that because of the death certificate that pensionary benefit could
Then
not
you
be.
have to impede the state of Assam.
Lordship.
It's trans border.
What I'll do, Lordship, state of Assam, that health and family welfare department, Lordship. That I'll do.
It's the unified affidavit.
We've already filed, your lordship.
File, Lordship.
Ms. E. Pasa after respondent number
4, lordship.
4 prays for allowed further 2 weeks time to file affidavit. Stop Mr. S. A. Sheikh has also made a prayer that we will allow to implead for the necessary party, which is the state of Assam, as the register of birth and death is from Gulpara district.
Gwalpara district.
Yes, prayers allowed.
Much obliged, Lord. 16.
File.
Yes, your lordship. Already
Finally,
filed.
my lord, they filed the affidavit. I was praying, my lord, if this matter could be fixed for hearing, my lord. In the meantime, my lord, if rejoinder is necessary, we'll file.
What kind of submission is that?
Well, I'm saying,
Studied the affidavit.
I've studied the affidavit, my lord. Only on one aspect I need some instruction.
Then you file a joint.
My lord, which time is good enough?
Strike out his surname, correct?
Right, my lord.
It's a very important matter. Yes, Mr. S. Thapa prays immediately without receive instructions as to whether rejoinder will be necessary. This after 2 weeks, yes.
Much obliged, lordship. 17.
Please, your lordship. Lordship, I'm praying if this matter may be taken up at the end of the board, lordship. The learned DSJ is currently on legs.
Your Lordship, I am appearing on behalf of respondent number 6. We have just received a notice and we could not file the work landmark because there's some landslide on the way to Shillong. So the client has not.
Landslide where?
Landslide on the way from Mizoram.
Where in Mizoram?
I just got instruction this morning that we have received a notice on behalf of respondent number 6.
Well, any instructions, Ms. Mitkan?
Lordship, we have.
What instructions are there?
Lordship, the DSJ will be in a better position, lordship, to place that.
After some time or tomorrow?
But Ms. Goyal is there in the online. We can have it at the end. That's what she has been submitting, Lord. We can have it.
Let it come up on Friday. Then there is an urgency because on the basis of fake documents, someone is taking.
As the learned DSI is not present in court, this is a matter on Friday. Order.
Highly obliged.
I'm grateful, my lord.
18.
Please, Your Lordship. Your Lordship, we are yet to receive instructions, Your Lordship. I'm praying further time may be allowed.
You're still in detention center?
Yes, Your Lordship. I'm still.
You've not been deported as yet?
Not yet, Your Lordship.
Longer you take, he'll be deported. In the meantime, what will happen? This looks like a dead-end case anyway. Further 2 weeks time allowed to the
Lordship, 1 week?
Yeah, 1 week they can't do anything.
2 weeks,
time, yes. We take up the matter for hearing. Which time to respondent number?
1, 2, 4 and 5.
1, 2, 4 and 5. And for 3 lots.
Okay, two. An affidavit.
Lordship?
You already filed your affidavit?
No, they have not filed yet, Lordship. We haven't filed yet, Your Lordship.
You filed it? You filed affidavit, yes. Then we take it up for hearing.
19.
May it please your lordship. I'm praying for some time, your lordship, to file our affidavit.
And for a 2 weeks time, as date allowed for affidavits thereafter and so on.
20.
Connected matter, your lordship. Connected matter, your lordship.
21.
Yes.
May it please your lordship. Your lordship, I pray some time, your lordship, to file the affidavit, your lordship.
Respondent may have taken steps.
Steps have been taken, Your Lordship.
Yes, office note indicates that notice not complete. Respondent by 8 stop. MSN number 427. So praise that. We allowed
to file
further
affidavit.
2 weeks time for affidavit. 1 and 2 no affidavit. On behalf of Respondent 1 and 2, MSS Barachaji submit that no affidavit forthcoming. So this after 2 weeks for affidavit and for service report on Respondent by 8. Yes.
Yes, Your Lordship. Deeply obliged, Your Lordship.
Second call, item number 1.
Yes. Have you collated the judgments?
Oh, yes.
So that otherwise it's very confusing for the court. Can you double orders in your time much near?
Sorry for the inconvenience caused.
No, it's all right. But the thing is, at least make it smooth. That's all.
Yes.
We'll be well advised, to make a compilation.
Right.
of the
Exactly.
judgments relying upon as a normal, it's done. And you hand over the compilation. You just say, judgment number 1, number 2. You flag it, and then it becomes very easy.
Actually, that was my instruction, but it could not be that way made.
It was not implemented.
I don't blame him. Possibly there is some shortcoming from me also. Anyway, my lord, the decision I gave, which one? Rathi Lal, my lord. Your lordship, I'll try to take your lordship to paragraph 11 and 13.
So what about this SCR?
Your lordship may discard that because the paragraphs will tally from my.
Ratilal Panachand.
Yes. Para 11 and 12.
This is on Article 26, correct?
Yes, in regard to Article 26. So far as Article 26 is concerned, it deals with a particular aspect of the subject of religious freedom. Under this article, any religious denomination or a section of it has the guaranteed right to establish and maintain instructions for religious and charitable purposes and to manage in its own way all affairs in matters of religion. The rights are also given to such denomination or a section of it to acquire and own movable and immovable properties and to administer such properties in accordance with law. The language of the two clauses B and D of the Article 26 would at once bring out the difference between the two. In regard to affairs in matters of religion, the right of management given to a religious body is a guaranteed fundamental right which no legislation can take away. On the other hand, as regards the administration of property which a religious denomination is entitled to own and acquire, it has undoubtedly the right to administer such property, but only in accordance with law. This means that the state can regulate the administration of trust properties by means of laws validly enacted, but here again it should be remembered that under Article 26D, it is a religious denomination itself which has given the right to administer its own property in accordance with law, which the state may validly impose. A law which takes away the right of administration altogether from the religious denomination and vests in any other or secular authority would amount to violation of the right which is guaranteed by Article 26D of the Constitution. The moot point for consideration therefore is, where is the line to be drawn between what are matters of religion and what are not? Our constitution maker have made no attempt to define what religion is, and it is certainly not possible to frame any exhaustive definition of the word religion which would be applicable to all cases of persons. As has been indicated in the Madras case referred to above, the definition of religion given by so and so does not seem to us adequate or precise. The term religion thus observed, the learned judge in the case mentioned above has reference to one's views of his relation to his creator and to the obligations they impose or reverence for his being and character and of obedience to his will. It is often confounded with cultus of form or form of worship for a particular sect, but is distinguishable from the latter. It may be noted that religion is not necessarily theist, and in fact, there are well-known religions in India like Buddhism and Jainism which do not believe in existence of God or of any intelligent first cause. A religion undoubtedly has its basis in a systematic of beliefs and doctrines which are regarded by those who profess that religion to be conducive to their spiritual well-being. But it would not be correct to say, as seems to have been suggested by one of the learned judges of the Bombay High Court, that matters of religion are nothing but matters of religious faith and religious belief. Religion is not merely an opinion, doctrine, or belief, it has its outward expression in acts as well. We may quote in this connection the observation of so and so of the High Court of Australia. It is sometimes suggested in discussion on the subject of freedom of religion that though the civil government should not interfere with religious opinions, it nevertheless may deal as it pleases with any acts which are done in pursuance of religious belief without infringing the principle of freedom of religion. It appears to me to be difficult to maintain this distinction as relevant to be the interpretation of section 116. The section refers in express terms to the exercise of religion, and therefore it is intended to protect from the operation of any Commonwealth laws acts which are done in exercise of religion. Now, Your Lordship may turn to paragraph 13. The religious practices or performances of acts and pursuance of religious belief are as much a part of religion as faith or belief in particular doctrines. Thus, if the tenets of the Jain or the Parsi religion lay down that certain rites and ceremonies are to be performed at certain times and in a particular manner, it cannot be said that these are secular activities partaking of commercial or economic character simply because they involve expenditure of money or employment of priest or the use of marketable commodities. No outside authority has any right to say that these are not essential parts of religion, and it is not open to the secular authority of the state to restrict or prohibit them in any manner they like under the guise of administering the trust state. Of course, the scale of expenses to be incurred in connection with these religious observances may be and is a matter of administration of property belonging to religious institution, and if the expenses on these heads are likely to deplete the endowed properties or affect the stability of the institution, proper control can certainly be exercised by state agencies as the law provides. We may refer in this connection to the observance of Dabar in the case of Jamshed so and so, and although they were made in a case where the question was whether the bequest of property by a Parsi testator for the purpose of perpetual celebration of ceremonies like so and so, which are sanctioned by the Zoroastrian religion, were valid charitable gifts, the observance we think are quite appropriate for our present purpose. If this is the belief of the community, thus observed the learned judge, and it is proved undoubtedly to be the belief of the so and so, a secular judge is bound to accept that belief. It is not for him to sit in judgment on that belief. He has no right to interfere with the conscience of a donor who makes a gift in favor of what he believes to be the advancement of his religion and the welfare of his community or mankind. These observations do, in our opinion, afford an indication of the measure of protection that is given by Article 26B of our Constitution. 20. Now I will take your lordships to a decision that is 2004-12 SCC, page 770.
2024?
2004-12 SCC, 12 SCC,
Yes.
page 770.
77. Paragraph?
Paragraph 59, 60, 62 and 66.
59, 60.
60, then 62, then 66. This is their lordship as my lord explained in regard to public peace, tranquility and all that.
Okay, that'll be important. Yes.
Yes, in para 59 onwards, the lordship will find.
Yes.
These observations were quoted with approval by this court in Ghulam Abbas versus so and so. It was observed that the authorities should not, in the face of such religious rights, prohibit religious procession on the facile ground of public peace and tranquility, but adopt a positive approach to protect fundamental rights under Article 25 and 26 of the Constitution. Moreover, public order has a larger connotation than law and order. Contravention of law to affect public order must affect the community or the public at large. A mere disturbance of law and order leading to disorder is not one which affects public order. Similar possession, now paragraph 62, my lord. 61, your lordship may skip. 62, the police commissioner answers the charge of discrimination by stating that activities of Anand Margis cannot come within the scope of religious functions or practices as compared to well-established practices in festivals of Muslims and Sikhs. It is not for the police commissioner to give his disapproval to a practice of a particular sect which is, in his opinion, well established, to allow any authority to judge the truth of falsity of a religious belief or practice is to destroy the guarantee of religious freedom in the Constitution. Then paragraph 64. Whilst our Constitution is neutral in religion, it at the same time is benign and sympathetic of all religious creeds, however unacceptable they may be in the eyes of the non-believers. Articles 25 and 26 embody a tolerance for all religions. This court has rightly said, our tradition teaches tolerance, our philosophy preaches tolerance, our constitution practices tolerance, let us not dilute it. It is in that spirit of tolerance that creeds like the petitioner with their practices must be accepted in our society. Paragraph 65. This court has explained in a number of decisions that what constitutes an essential part of a religion is primarily to be ascertained with reference to the doctrine of that religion itself, and that the country cannot say that a belief or practice is not part of religion. This proposition was authoritatively laid down by the Constitution Bench in this court by 7 judges, that is Srimur Murthy case. Then para 66, the case of Rathilal Panchad Gandhi versus State of Bombay. No outside authority has any right to say that these are not essential parts of religion, and it is not open to the secular authority of the state to restrict or prohibit them in any manner, the like under the guise of administering the trust state. This court quoted the approval of so and so. If this is the belief of the community, a secular judge is bound to accept that belief. It is not for him to sit in judgment on that belief. He has no right to interfere with the conscience of a donor who makes a gift in favor of what he believes to be an advancement of this religion and for welfare of his community of mankind. Then your lordship may turn to paragraph 76 onwards.
76?
76, 77, 78, yes. 76 to 78, my lord. The full concept, para 76 reads like this. The full concept and scope of religious freedom is that there are no restraints upon the free exercise of religion according to the dictates of one's conscience or upon the right to freely profess, practice and propagate religion, save those imposed under the police power of the state and the other provisions of Part 3 of the Constitution. This means the right to worship God according to the dictates of one's conscience. Man's relation to his God is made no concern of the state. Freedom of conscience and religious belief cannot, however, be set up to avoid those duties which even citizen owes to the nation, to receive military training or to take an oath expressing willingness to perform military service and so on. Though the freedom of conscience and religious belief are absolute, the right to act in exercise of man's freedom of conscience and freedom of religion cannot override public interest and morals of the society, and in that view it is competent for the state to suppress such religious activities which are prejudicial to public interest. That apart, any activity in furtherance of religious belief must be subordinate to the criminal laws of the country. It must be remembered that crime will not become less odious because it is sanctioned by what a particular sect may designate as religious. Thus, polygamy or bigamy may be prohibited or made a ground of disqualification for the exercise of political rights, notwithstanding the fact that it is in accordance with the creed of a religious body. The liberty of the individual to do as he pleases, even in innocent matters, must yield to the common good. In other words, the police power of the state is founded on the theory that when there is a conflict between the rights of an individual and the interest of society, the interest of society prevail. In an organized society, there cannot be any individual right which is injurious to the community as a whole. At the same time, the police power is not absolute and must not be arbitrary or oppressive. In other words, the police power must be exercised for preservation of the community from injury. Whatever Constitution attempts to do is to strike a balance between the individual liberty and social control. There are two limbs of religious freedom contained in Article 25. While one limb guarantees the right, the other limb incorporates restrictions on the exercise of the right so that it may not conflict with the public welfare or morality. Then paragraph 88 also, my lord. Therefore, Ananda Margis have the right to take out a procession in public places after obtaining necessary permission from the authorities concerned, and they are also entitled to carry trishul or trident, conch or skull, so long as such procession is peaceful and does not offend the religious sentiments of other people who equally enjoy the fundamental right to exercise their religious freedom. And Ananda Margi is entitled to transmit or spread religion by taking out procession in public places and also carry trishul, conch or skull. However, any religious right is subject to public order. The state has got ample power to regulate the secular activities associated with religious practices. Religious activities are protected under Article 25 of the Constitution. No doubt such religious freedom is subject to health and subject to laws made for social welfare. Every person has got the right to follow, practice and propagate his religion. The Commissioner has got power to regulate assemblies, meetings and procession in public places. It specifically provides that he is entitled to prescribe the roads by which and the times at which such procession may pass in order to keep the public places and prevent obstruction on the occasion of such assemblies, meetings and procession in the neighborhood of places of worship during the time of public worship. Hence, to preserve public peace and to avoid damages to public properties, and keeping this in mind, the Ananda Margis are permitted to go on procession and perform so and so, so and so. Now, the Commissioner of Police, my lord, he will have to maintain certain things. He cannot say, he cannot take a decision that these are not permitted. Your duty is to see whether there is a disruption of public order. Now, here in this impugn order, your lordship has seen, there is no reflection of whether there is a disruption of public order, morality and health. Now, as such, my lord, the DC cannot pass an order as he likes, because he is not a constitutional authority or a parliament who can, my lord, amend the constitutional provision. Now, he assumes himself is a super parliamentary body. Now, my lord, I take your lordship that this judgment is your lordship is well known to your lordship. When you pass an order, impugn order, your satisfaction will have to be reflected when you can exercise that power. That power you can exercise subject to constitutional provisions. Now, there must be reflection on the order itself. By filing an affidavit, you cannot improve it. In that regard, my lord, I will take your lordship's two decisions. One is 1978 1 SCC 405, isn't it?
78 1 SSC.
Paragraph 8.
1978.
78, that's Mohinder Shinghil case, my lord.
Achha.
78 1 SCC 405. Paragraph 8. Just a small para, my lord, I'll just read out. $15 rule, I thought.
Para 8, correct?
Para 8, my lord.
Yes.
The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to court on account of a challenge, get validated by additional grounds later brought out. We may here draw attention to the observation of Bose J in Gardan case that your lordship is well aware. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the things, the actings and conduct of those to whom they are addressed, and must be construed objectively with reference to the language used in the order itself. Orders are not like old wine becoming better as they grow older. The next decision is 1951 SCC 1088. Paragraph 9. The similar explanation, my lord. Paragraph 9. An attempt was made by referring to the commissioner's affidavit to show that this was really an order of cancellation made by him, and that the order was his order and not that of the government. We are clear that public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used.
The judgment refers to this only.
Yes, it has already been referred. Now, my lord, the next one, 2003 7 SCC 546.
You have all this, no?
2003.
2003 7 SCC 546. Here, my lord, the content of this case your lordship will find, if there is some difference of agreement between the two factions in the charge, the court will not enter into all that. Paragraph 64 and 68.
2003 7 SSC. Let's read it. So this is the judgment.
64 minutes.
Para 64.
Yes.
The court should be circumspect in entertaining such public interest litigation for another reason. There may be dispute amongst the devotees as to what practices should be followed by the temple authorities. There may be dispute as regards the rites and rituals to be performed in the temple or omission thereof. Any decision in favor of one sector of the people may hurt the sentiments of the other. The courts normally thus at the first instance would not enter into such disputed arena, particularly when by reason thereof the fundamental right of a group of devotees on Article 25 and 26 may be infringed. Like any other wing of the state, the courts also while passing an order should ensure the fundamental rights of a group of citizens under Article 25 and 26 are not infringed. Such care and caution on the part of the High Court would be a welcome step. Then paragraph 68. 68.
Yes,
The
got
court,
it.
the
Steps
court,
by mandamus.
the court steps in by mandamus when the state fails to perform its duty. It shall also step in when the discretion is exercised, but the same has not been done legally and validly. It steps in way of a judicial review over the orders passed. Existence of an alternative remedial writ is no bar to exercise jurisdiction under Article 226 of the Constitution of India, but ordinarily it will not do so unless it is found that an order has been passed wholly without jurisdiction or contradictory to the constitutional or statutory provisions, or where an order has been passed without complying with the principles of natural justice. Now, my first argument would be the order passed by the DC is wholly without jurisdiction and it is unconstitutional. Then, my lord, 1995 3 SCC, page 398. I'll take your lordships to paragraph 126. Paragraph 126, page 500.
Yes.
As pointed out earlier, the source of authority of a particular officer to act as a disciplinary authority and to dispense with the inquiry is derived from the service rules, while the source of his power to dispense with the disciplinary inquiry is derived from the second provision to Article 311(2). There cannot be an exercise on this, my lord. There cannot be an exercise of a power unless such power exists in law. If such power does not exist in law, the purported exercise of it would be an exercise of a non-existent power and would be void. The exercise of a power is therefore always referable to the source of such power and must be considered in conjunction with it. The court's attention. Now, other part your lordship may skip. My main thrust of the argument would
Source
be
of power.
source of power. If you do not have any source of power, then you cannot pass any order. Then the next decision is 2019 2 SCC, page 660. This, my lord, I will be referring, your lordship will find, and I will take your lordship to those pages where they have said on apprehension. My lord, the appeals court has said on anticipation you cannot pass any order. There will have to be happening because disruption of public order you will have to find out. Now you are making an apprehension that, oh God, there will be some problem, so let me assume that I have a jurisdiction. Now the relevant paragraph would be 64 to 67. I am reading, my lord. We find that the High Court, while disposing of the writ petition, also passed the following writ directions in para 20, which reads as under. Since an apprehension is expressed and a serious one by the petitioners, we direct that in the event the fourth respondent passes any orders adverse to the petitioners, then such orders shall not take effect for a period of 4 weeks from the date they are communicated to the petitioners. Since we have set aside the fourth respondent's interim order and for the present not expressed any opinion on the contention raised before us, interest of justice demands that the sealing of the premises by the authorities should be set aside. Therefore, the superintendent or other functionary is directed to remove the seal, lock and key placed on the premises forthwith. This order will ensure to the benefit of such of the petitioners whose licenses are subsisting and are not cancelled. The other licenses which are no longer in operation on account of their termination, the holders thereof cannot avail the benefit of this order. However, we do express any opinion on the remedies that are available to them. In our considered view, the High Court ought not to have issued directions of this nature. It was legally not permissible to do so. Indeed, the High Court, by issuing such directions, which are essentially passed in anticipation of the order being passed by the appellate authority, interfered with the judicial independence of an appellate authority in deciding the appeals in accordance with the law. It is the sole discretion of the appellate authority under the Act to decide the appeal based on the facts involved in the appeal and legal provisions which eventually result in passing a judicial order. No higher court can pass such directions merely on anticipation of an order being passed by an appellate authority. It is only after order of passed that the aggrieved person has a legal right to take recourse to a legal remedy available in law against such order by approaching to a higher forum and pray for a grant of appropriate relief against such order. This stage in this case is yet to arrive. The High Court should not have, therefore, preempted the passing of any order of the appellate authority while deciding the writ petition. It is a settled law that the court can stay or quash only those orders which are impugned in the lease before it. A fortiori, the court cannot stay or to quash the orders in anticipation. Now here, my lord, they apprehended because we file a complaint that there may be a breach of law and order. Therefore, my lord, we sought protection of the police power. My lord, they construe now because we have asked for that, so there is a purported breach of public order, morality and all these things. Then the last but not the least, my lord, assuming, my lord, this is a case of ecclesiastical affairs has been breached. Now what will happen? Well, the party aggrieved has to go to the civil court. That has been decided by the appeals court in a constitutional bench judgment. Now, that is, my lord, 1995 supplementary 4 SCC 286. Paragraph 33 and 38. Your Lordship, can look at paragraph 33.
Yes.
On the plain phraseology of the section, therefore it is clear that a suit filed after coming into force of the Constitution for vindication of rights related to worship, status, office, or property is maintainable in civil court, and it would be duty of the court to decide even purely religious questions if they have a material bearing on the right alleged in the plaint regarding worship, status, or office or property. Where there were now this much for this paragraph 33, then paragraph 38. Religion is the belief which binds spiritual nature of man to supernatural being. It includes worship, belief, faith, devotion, etc., and extends to rituals. Religious rights is the right of a person believing in a particular faith, practice it, preach, and profess it. It is a civil nature. The dispute about the religious office is a civil dispute as it involves disputes relating to rights which may be religious in nature but are civil in consequence. Civil wrong is explained by Salmond as private wrong. He has extracted Backstone, who has described private wrongs as infringement or privation of the private or civil rights belonging to individuals. Your Lordship can see that civil wrong is explained by Salmond so and so, so and so. Now, any infringements with a right as a member of any religious order is violative of civil wrong. This is the letter and spirit of explanation 1 to section 9. Your Lordship, with the explanation 1 to section 9 of CPC, exactly that has been constituted. So therefore, my lord, even if there is some civil wrong somewhere between the parties, the aggrieved party is required to go before the civil court. Even, my lord, I rely one of your Lordship judgment that is came in, my lord, second appeal, your Lordship remanded back. So your Lordship is of the opinion that the civil is 2021 SCC online Meghalaya 219.
Yeah.
So your Lordship is already aware of that situation. And then this one will be 2014. So, my lord, in regard to the constitutional morality, as envisaged under Article 25 and 26, my lord, I would like to take your Lordship to a decision of Appeals Court referred in this court 2014. Did not give. 2014 9 SCC, page 1. 2014 9 SCC, page 1.
Yes.
Paragraph, I'll read from paragraph 74, my lord.
How much longer will it take, Mr. Datta?
No, my lord, I'll be winding up, just 10 minutes, my lord.
Yes.
Paragraph 74, my lord. The Constitution of India is a living instrument with capabilities of enormous dynamism. It is a constitution made for a progressive society. Working of such a constitution depends upon the prevalent atmosphere and conditions. Dr. Ambedkar had throughout the debate felt that the constitution can live and grow on the bedrock of constitutional morality. Speaking on the same, he said, constitutional morality is not a natural sentiment, it has to be cultivated. We must realize that our people have yet to learn it. Democracy in India is only a top dressing on an Indian soil, which is essentially undemocratic. The principle of constitutional morality basically means to bow down to the norms of the constitution and not to act in a manner which would become violative of the rule of law or reflectable of action in an arbitrary manner. It actually works as the fulcrum and guides as a lesser beam in the institution building. The tradition and conventions have to grow to sustain the value of such a morality. The democratic values survive and become successful where the people at large and the persons in charge of the institution are strictly guided by the constitutional parameters without paying the path of deviancy and reflecting an action of the primary concern to maintain the institutional integrity and the required constitutional restraints. Commitment to the constitution, this line is very important, my lord. Commitment to the constitution is a facet, constitutional morality. In this context, the following passages would be apt to be reproduced. If men were angels, no government would be necessary. Very important line, possibly nowhere in the world your lordship will find that. Now, in framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed and in the context place oblige it to control itself. A dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of auxiliary precautions. Then, my lord, in regard to the doctrine of good governance, that your lordship will find paragraph 77. Having stated about the aspect of constitutional morality, we presently proceed to deal with the doctrine of good governance. In so and so, the doctrine of good governance requires the government to rise above their political interest and act only in public interest and for the welfare of the people. Now, exactly, my lord, if your lordship sees the impugn order, it seems the concept of good governance has been given a goodbye. My lord, their political masters.
What about the other impugn orders, Datta?
Those are in the same line.
They are. I think in the earlier hearing, I noted down the.
My lord.
From 10, they were 12/3/26.
Right.
8/5/26 letter banning external interference. 13/5/26 show cause, no third party till, then 18/6/26, then 19/6/26.
Right,
Supporting religious sacrament.
Well,
19/6/26, the last one which you are.
I'll reply one by one to all.
These are all in what do you call it? Linked.
Yes,
together.
yes,
So that's so only that part.
Right. I'll
why are
argue.
you pinning them from
I'll
the
argue on that also.
meeting, the minutes 8/12/3/26, 8/5/26, 13/5/26.
My lord, I'll take your lordships one by one. Your lordship kindly see at, I'll start from page 57. How
We have finished with the judgments.
A judgment all over, my lord. That those judgments were for my satisfaction. I do not know how much I could persuade your lordships. Page 57, my lord. That is the letter from the joint register. He has disposed of this matter relating to Maukhar Presbyterian Church. This is dated 10th February 2026. Page 57. Your lordship will
I was
find.
looking at my small note and made last time. Yes. Okay. Yes.
Now, these, your lordship kindly see the contents. With reference to the subject cited above, I have the honor to inform you that the matter relating to Maukhar Presbyterian Church was heard on 10th February, room number so and so. The first party, Sri so and so, on behalf of the society Maukhar Presbyterian Church, stated that their society, namely Maukhar Presbyterian Church Shillong, was registered on 22nd January 2015, bearing registration number so and subsequently renewed on 15th October 2025, bearing registration number so and so. The registration and renewal were carried out in accordance with procedure as per the Registration Act. The second party so and so on behalf of the church committee of Maukhar Presbyterian Church stated that they have no objection to the renewal of the society. However, they objected to the amendments made to the society, stating that such amendments are an internal matter of the organization. Upon hearing both the parties, it was observed that the issue arose due to misunderstanding relating to the amendments of the organization, which pertains to the internal affairs of the society and not to the renewal of the said society as per section 10 of the Registration Act. Now ultimately this has been disposed of. Now these are the matters. Now the DC is saying until disposal by the joint register. Now joint register further wanted certain clarification from us. We have very vividly, my lord, explained all this. Now it is pending before him. Now how related to the impugn order with this? If it is pending before the joint register, what DC has to do?
Get two separate matters.
Yes, it's not related at all, my lord. Now, your lordship kindly see, this is, I will just say this is a high-handed action. I do not know whether by him or by the political masters he has been dictated to do that. My lord, your lordship, now please come to page 78. This minutes of meeting. The meeting was presided over by so and so, highest Deputy Commissioner East Kashmir Hills. The chair stated that the purpose of the meeting is to discuss the matter relating to issue arising out of disagreement between the two factions of the members of the Maukhar Presbyterian Church, Shillong, which may lead to breakdown of law and order. May lead to, your lordship kindly see the wording, may lead to breakdown. The chair also pointed out that the district administration does not want to interfere in the internal management of the church activities. However, the present discord, complaints and counter complaints between the two factions have necessitated the district authorities to step in order to resolve these issues, since the church has about 9,200 members. Initiating the discussion, the chair stated that there are two issues to be discussed in the meeting: law and order and the registration of societies. The chair pointed out that it is reported that the present discord between the two factions is creating a discontent among the members of the church which is evident from the FIR and counter FIR filed against each other. The chair then requested the additional superintendent of police and OC of so-and-so to brief on the status of the FIR. The additional superintendent of police informed that FIR and counter FIR was received at so-and-so police station. The preliminary investigation is under progress and sought for more time to collect evidences and record the statements and witnesses. The chair then requested the police to speed up the inquiry and to submit the report at the earliest. With regard to registration of the church under Meghalaya Society Registration Act, the chair stated that the management of the church is governed by its memorandum and regulations duly approved by the Register of Societies is an internal and separate matter with the district authorities, does not want to interfere with. However, she pointed out that a society registered under the said Act shall not alter its memorandum except with the previous permission of the register in writing. The alteration should then be approved by a majority so-and-so. Further, a society may be dissolved if at a special general meeting convened for the purpose by the votes of 3/4 of the members, it passes a resolution for dissolution. As such, these issues regarding the management of the church as a society has to be taken up with the appropriate authority. After threadbare discussion, the following decisions were taken. The superintendent of police is required to speed up the inquiry and submit the report. Based upon the inquiry, both parties should be directed to exercise a bond for keeping the peace subject to the following conditions. The church service for the members should not be closed. There should not be an obstruction for performing the last burial rites of any member of the church. The list of the property like schools, hall, etc. is attached to the church should be submitted to the district administration and the police. No meeting should be held in such properties including church premises until the matter is resolved. Now I'll just take your lordship to page 87. What is the position of the criminal case? Lordship will find that at page 87 they found nothing and ultimately it has been disposed. This is the order dated 4/5/2026. Here put up today. Seen and peruse the written submission submitted by so-and-so. Furthermore, seen and peruse the police report dated so-and-so. In careful consideration of the material on record and having closely examined the facts and circumstances of the instant case, this court is of the considered opinion that the instant matter is not a fit case for further proceedings under section so-and-so, as the aforementioned police report indicates that the Maukhar Presbyterian Church is conducting church services as usual without any obstruction from any quarters. Concerned parties are at liberty to approach the competent forum for adjudication and settlement of their instant matter. As such, the matter is liable to be dismissed and is therefore dismissed. Accordingly, case disposed of. Now, the police investigation is all over, as the executive minister found there is nothing. Then your lordship will find, I'd like to skip that. Your lordship may come to page 85. There's a letter. RTI, my lord. Whereas the office of the undersigned has received an application from so-and-so under section so-and-so to make available the following information. Provide copy of registration, provide copy of constitution memorandum, and all to provide all these things, and we have provided all that. Then your lordship may see at page 86. It's written by member secretary.
We'll just go to the letters if impugned. That's the only
Yes.
thing, the content. That is what this court has shown earlier. That is 8526 as a
8520 at page 89.
We already placed it. That is a meeting, correct?
Yes, I'll take your lordship.
The meeting is 12/3. Then 8526. Let this is
8526 at page 89. Your lordship kindly see this. Mr. So-and-so, it is by the deputy commissioner. With reference to the subject cited above and in continuation to the minutes of the meeting,
no external influence.
referred above in the office chamber of
The whole
undersigned.
case hinges on this. This one authorities do not have any jurisdiction to issue any orders with regard to interference with the internal matters of conduct
Yes,
of religious
exactly.
services and
It is on
practice.
that issue.
That's all. That is your stand.
Yeah, exactly.
That that they had no right.
Right.
And that, yes. So yes.
No.
that you're free, and so this is, you agree with that.
Yes.
However, however, no other external interference. That means external interference is your affiliation with the other synod, right?
Other synod,
which
my lord.
you feel prevented by these orders.
Rightly, my lord. The DC, my lord, construed that synod from other synod, my lord, we cannot bring.
No, he's just replicated whatever the
Complaint
has
rightly,
apprised him. There's only thing. So in his own judgment, he says, okay, fine, there's no interference, and apprehension of some breach of PCS. The next order will
as
be,
a result, what happened to us, my lord? The pastoral service, like
everything
administration
is
of all these things have been stalled.
Yes.
We cannot hold any meeting. My lord, should be a meeting of annual general meeting, my lord, in regard to ITR and all these things. These are all in a halt stage, my lord. So therefore, whether DC has exceeded its jurisdiction, that is the only very short question involved.
That's court of us has said from the beginning that we will confine our hearing only to that part, whether
up to that much.
Are the judicious enough.
Exactly, my lord.
That's all. And there to show that yes, the orders pass for in the scheme of
the state has to
the state or
persuade
even the respondents how to support the orders have been passed by and added with their submission that this matter is purely internal matter.
Exactly.
Which is to be settled by the mechanism which is within the church itself. Yes.
And even, my lord, there are two ways. If even there is some internal problem is going on, now who has to settle it? But the best course to be, my lord, so far the constitutional man judgment is concerned, go to civil court. The party agreed, you have to go to civil court. Your lordship has also endorsed to that. Now, therefore, other problem, my lord, if they argue that it should go to the hierarchy of the, my lord, the local authorities. Now, the Presbyterian, if your lordship look at the constitution, the Presbyterian, your lordship will find the first authority is the local authority.
Yes.
The jurisdiction goes to there. Then after that, if they are not satisfied, it will go higher up. That's the legal position, my lord. So, my lord, my submission would be squarely on that only. And if, my lord, after their argument, if something remains to be argued, my lord, I will.
Yes.
My lord, your lordship is sitting in the second half.
So we have full court meeting, but we'll rise around 15.
We'll have a little difficulty today. As a matter of fact, 1 o'clock. There is some issue.
So we'll continue when, Mr. Datta?
Today's some meeting. What some meeting is there?
Yes, I believe some past.
There's some internal issues.
Today is the 5th.
Well, today is the 5th.
So we'll post it on the 12th. You please conclude, or before that also we can post it on 10th.
Your lordship, just give me 1 minute time. Let me see my diary.
So we've understood your case. Yes.
My lord.
I hope we have understood. Yes. And it depends on Mr. Shulai now to defend the orders of the Deputy Commissioner.
Next week, try to satisfy your order. Tomorrow again he has DB.
DB ko hai?
Tuesday, Thursday.
Achha. Tuesday the 12th?
12th?
12th is okay. 12th is okay.
Yeah, just for further hearing on 12th.
I leave that.
Much over.
Hearing 23.
Yesterday received one affidavit from the petitioner.
Who's for the petitioner? Who's for the petitioner? What affidavit?
There is a new affidavit based upon certain new factual averments have been made On the last occasion, Your Lordship had granted
Mr. S. Pandey
time
submits
to-
that fresh affidavit has just been filed by the submits that the petitioner has put on record an affidavit bringing
certain new factual developments. Your Lordship.
the new factual development stuff. You want to file reply to that?
Yes, Your Lordship.
The brief was allowed
2 weeks time.
time to file a reply to the same, at least up to 2 weeks. Yes.
25.
Lords, I'm sorry, I am in the item number 23.
Milord, I am also in item number 23, Milord. My apologies, Milord, could
No,
not.
they've given them time to file a rejoinder to your affidavit. Yes.
And Milord, my appearance, please be marked. Milord.
Yes, we mark.
What date has been
Hey,
given for
Gupta.
final argument?
Date begun by court master. Yes. After 2 weeks. Yes. Yes.
Lordship, I have this matter next week, Your Lordship.
What's the matter about?
This is a regularization, Your Lordship.
This matter was heard at length, my lord. The only thing left is for the state to produce the minutes of the
I'll
meeting.
just go through that file.
Where's the minutes of the meeting?
Lordship, I just received, Your Lordship, so...
The minutes when you just received them?
Lordship, yes. Come next week, Your Lordship.
After 1 week, yes.
1 week.
On the prayer of Indi
Up to
Shulai.
28, no? Up to
Double
28.
EG, yes.
Up to 28, Your Lordship.
After?
Up to 28, 25 to 28, Your Lordship. After a week only, Your Lordship.
Probably as Ms. Elisha submits that the minutes, what have you received?
Lordship, the proceeding of the department regularization committee, Your Lordship.
Yes.
Let them place on record also, my lord.
Instructions have just been received with regard to realization of the petitioners.
Yes.
He placed a matter list up to 1 week.
Let them
also permitted to bring the same on record by way of
Lordship will produce the original, will place.
Let them bring on record also, my lord, who has constituted that departmental promotion committee.
Now you heard him, yes.
Yeah, that's very important, my lord.
Lordship, the record will speak by itself.
Record always speaks by itself. Yes.
33.
33 at 2 o'clock. Last item, yeah?
34.
33 at 2 o'clock?
Not.
34, who's at
34.
2 o'clock, 2:15, whatever, yes.
Your Lordship, I have received instructions from the client to withdraw this matter, Your Lordship, with liberty to file fresh.
This matter is this.
This pertains to non-payment of salary, Your Lordship, from Bagmara Municipal.
Last time lawyer, there comes with the place to withdraw this application with liberty to file a fresh if so advised. Praise allowed, matter signed proposed on withdrawal, however, liberty has paid.
Your Lordship.
Last time matter 33. Seeking time.
May it please Your Lordship. Your Lordship, with the consent of the counsel for the petitioner, Your Lordship, I pray that this matter may be placed tomorrow because learned Dr. Muzika has to attend the meeting, Your Lordship.
What meeting?
Some of the bar, Your Lordship.
This is the. There are two matters, correct?
Yes, Your Lordship.
This is which one? The earlier one or the later one?
PC 427
It's
of
the earlier one.
2025. Yes, Your Lordship.
Is the 226 one also?
No, Your Lordship, is not fixed today, Your Lordship.
No, there's not a 2026 matter.
Yes, Your Lordship.
Let him come lazy. Huh?
I think he's outside, Your Lordship.
This one where the hearing was concluded, then additional affidavit was filed. Where is it, Mr. Gupta?
Sorry, Your Lordship.
Tomorrow?
Yes, Your Lordship, we will take it up tomorrow.
What happened?
Because, sir, it's not, because of the meeting is ongoing meeting, Your Lordship, so they said that we'll fix it tomorrow.
Tomorrow DB. Anyway, we'll give it a try tomorrow, yes. On the pre accounts for the parties. This is a matter tomorrow.
Highly obliged, Lordship.
Yeah, bye.